Good evening to you all. Before any substantive discussion, we would like to give you the opportunity to uh, have some kind of interactive Q&A session with you. So, if there's anything you'd like to bring up, please feel free and do that.
Yes, good evening, Your Lordship.
Good evening.
It's Emmanuel.
Yes, Ima, let's hear you.
Yes, my Lord. So, my question is actually coming from immovable property side. I don't know if I'm permitted to ask that, sir.
Okay.
Okay. So, with respect to the Rent Act, the general rule is that the right of recovery of possession, where the tenant breach a term of the agreement, for instance, failure to pay rent, will amount to or will grant the landlord the right to recovery of possession. However, there's a clause that where the landlord failed to exercise or indicate to the tenant that even though you've breached the agreement, now that you've paid the rent, I'm still going to enforce that my right to recovery of possession. Is there any explicit provision in the Rent Act of 1960, I think 63, which provides for that explicitly?
Well, I think you are talking with reference to section 17.
Yes, my lord, section 17.
Yeah, so what is the problem with section 17?
So, my lord, I've come across readings where they will tell you that the right to recovery of possession by the landlord.
Yes.
Yes. And in that, one of the provisions has been that one of the grounds for recovery of possession by the landlord is that where the tenant fails to pay a breach,
Yeah, he default
of
in the payment of the rent.
default in the payment of the rent. Under the Rent Act, it say 1 month, but there are times where the parties to the agreement may subject it to their own terms, may say 3 months or 6 months, where they explicitly provide for that, or where it is within the 1 month as per the provisions of the Rent Act. Um, is it automatic that the landlord may exercise his right of possession automatically by the breach of that as a result of the default in the payment, or he need to further exercise some right and indicate to it? Because I read in a material which said that the landlord might have indicated to the tenant before exercising that right. That's what I seek a clarity on.
So if there has been a breach of a covenant or obligation under the Tenancy Act, that will have to be brought to the notice of the tenant. But in terms of rent, the argument will be that where you are defaulted in paying rent, you know that you defaulted in paying rent. However, you still need to go to, you need to go to court or the rent magistrate, as it were, in order to get a formal order. And you don't resort to, as we've seen in some of the case law, where somebody will go and just remove the roof of the house, or just create some other self-help measures in order to compel the tenant to live there. Of course, the tenant become what we call like a statutory tenant once he or she has, is in a default and you have engaged the processes for removal. So you need to either go to the rent magistrate or go to the appropriate forum, depending upon whether you want to go to like the district court or even like the high court, as the case may be. But usually for tenancy matters, you can just go to the rent tribunal or the rent magistrate and get this rectified. So there's a default in payment of rent. That is a consideration for the tenancy agreement. You have the right to exercise recovery or repossess. So if you look at section 17.1, let me just look at the law. Subject to subsection 2 of section 25 and section 28, another against a tenant for the recovery of possession of or the judgment from any premises shall not be made or given by the rent magistrate or any other judge of a court of competent jurisdiction in accordance with any other enactment except A, where a rent lawfully due from the tenant has not been paid or tendered within 1 month after the date on which it became lawfully due. So, and so on and so on, the rest follows. So where the rent has become due and the person has defaulted, like a normal debt recovery, you need to notify the person. But once you've notified the person, it doesn't mean you have to serve the notice before you go to court. But if you go to the rent magistrate or any court, that in itself, because the process will be served on the tenant, the defaulting tenant. Of course, the defaulting tenant already knows that he's defaulted in paying the rent. Okay.
Very, very well, my lord. My lord, the last one, if I may,
Yes.
under the same act, section 36.
36. Okay.
Under the same rent act, section 36, where the definition of terms, the definition for a member, a family member, as provided for under the section 36.
Interpretation session.
Yeah, the interpretation section of the Rent Act 1963.
Yes.
So the definition for a family member, a member of a family, it explicitly made mention of mother, wife, husband, child, brother or sister, father. And it continued by saying, or any other person as may be prescribed, as may be prescribed. My lord, if you could humbly give a brief explanation to us maybe prescribed, because there was an argument or a discussion between a study mate and us, and we were saying that as may be prescribed, either the court prescribed that and said that, okay, in this case, a grandchild may fall under the member of a family, as the law mentioned. So if your lordship could just help with a little on that. So
yeah, so if I understand you, the ending of that definition, after listing the father, mother, son, sister, and so on, and then adding as may be prescribed as to what does it mean? And then who is going to do the prescription? Is that your point?
Yes, my lord, please.
Okay,
that's fine.
Good. Okay, good. I have not come across any case law which has sought to provide any attempt to use that clause in terms of reading other persons into the list provided in section 36, as you rightly say, who family members are for purposes of the act. That means the father, mother, wife, husband, child, brother or sister, or any other person as may be prescribed. Okay, an argument may be that if you look at the Children's Act, okay, the Children's Act also talks about children by adoption, okay? That when you have adopted a person, the person is entitled to all legal rights and protection in the case of like a biological child. So, as may be prescribed here, uh, like can liberally be interpreted to encapsulate, for example, non, if you like, not when you mention a child, when you mention a child, automatically, what brother, sister, child, what comes to mind? Uh, Biological. That is the first thing which comes to mind. But then we also know that as a matter of law, where a person has gone through legal process of adoption, the person also acquired the status of a child. So this act was 1963. Of course, we had the adoption act, but some adoption was done in the past, but then the Children's Act, as amended, has actually come to clarify the parameters. So an argument will be made that as prescribed by law would also include situations like the adoption law and people who acquire the status of a child and adoption law. Or it may also be interpreted to mean any other situation in which the lawmaker will make a law and say that for purposes of maybe social protection, okay? So there's this law which is supposed to have been passed, the Social Protection Bill. For purposes of social protection, maybe certain people who may not qualify as a child, a brother or sister, but then he or she, for example, has become like a dependent in a very special way, that could also be treated as a member of the family, as it were. If you look at the Person with Disability Act, as well, for example, and in order to give social protection to some other people for specific purposes, the law may include some others as constituting part of the family. So that could possibly be one of the ways in which the open-ended phrase as prescribed by law could mean. Okay?
Very well, my lord. I think, my lord, just a quick one. So the use of the description or the definition for member of a family here was still with respect to the section 17 that I mentioned earlier. Under the right to recovery of possession or the right to recover possession of
Yes.
by a landlord. There are certain people that the act provides for that if the landlord is actually recovering for those people for personal use, as the
For the
act
family
puts it.
members, yeah.
Yes, please. So that is why I asked with respect to that. I'm very
Yes,
grateful.
very well. Okay, good. Any other?
Good evening.
Yes, proceed.
Yeah. Please, I want to ask a question in relation to since concerning land. Please, with the gifts, that is the acquisition through a gift, or let's say alienation through a gift, if it's been given to, let's say, a non-subject, can the person extend it, or you must be a subject to have that right to extend the land? Thank you.
Let me understand. If I understand you, you want to find out whether
Yeah.
a gift of
When you are being given the land, you are being granted the land by the principal, or let's say the chief and the principal this of, let's say, the two. Can you extend the land to include other portions?
Okay, let me clarify. So if I understand you, if whether a family land or school land, a gift of it can be made to a stranger. Is that the case?
No, please. So it's being given to a stranger as a gift, but the
Okay.
stranger is extending the land to other portions. And I'm asking, would that one be valid if the stranger does that?
Oh, but
Is
certainly,
it a valid?
no, you see, where you'll be given a grant, regardless of
Yes.
whether by gift or whether by a formal grant, right? In
All right.
terms of the scope or the identity of the land, what you are be given is what you have. And
Okay.
if, for example, we be given just a particular, dimension or parcel of land, by no stretch of imagination, you can go beyond that. If you go beyond that, if it was a deed or gift, it doesn't cover the extra space that you are trying to acquire. If it was like a grant, because the land, will have been described in the schedule or the particular identity of the land will have been clearly delineated. So whatever acquisition that you are getting by way of gift, by way of grant, is limited to that which was given. And if you do any other thing, you are committing trespass.
Okay. Thank you. And please, is there a case in relation to that?
Oh, a case in relation to
The answer you
trespass.
just gave.
To trespass.
Yes.
No,
Yes.
the cases for declaration of title, uh, that
Okay.
we do, all of them uh, are authorities. Almost
All
every
right.
in which the court has made the declaration of title, in a sense, uh, would relate to the point that whatever land that you have been given or you've acquired, whether by deed, I mean by gift or by grant in any other way, is limited to the particular identity of land which the transaction relates to. So Brown and Kwashiga, Mechanical Lloyd, and Neat at
O-
Struby, all the you can get over 200 cases.
All right. All right.
Mm.
Thank you.
Yeah. Yes.
My Lord, I humbly, Emmanuel, let me come in here. So I think two major authorities that the court has always mentioned, that with respect to an express grant to a non-indigenous has always been Frimpong versus Poku, and then the Ulaya Atibukusu versus Oponkofi. I think those are the two major authorities have said that where a non-indigenous is granted a usufructual interest, they cannot extend beyond the original portion that has been granted to them.
Oh, I think her question, I didn't see, well, unless you've interpreted her question to mean that if that is in relation to whether a usufruct can be given to a non-digent, then that is fine. But I thought she asked a general question that if a gift of land has been given to you by the family with the stool, can you extend it? But
Yes,
if
please.
a
It was
concern
general.
if a concern is about the principle that a family member, when you are exercising its statutory interest in respect of the family or land, you can have it up to wherever your machete can cultivate up to, as whether that is applicable if it was given to a stranger, that is a non family to land member, whether that also applies, then that would be like a different matter. All right. So any other?
Okay. Sir, please, this one is in relation to torts.
Okay.
I'd wanted to find out concerning the defenses. In case you have a question in relation to that, can you state it as the defenses to intentional torts, or that will make it wrong? Being the accident, the necessity, the act of God, or it differs among
All
the
right. Okay,
various
thank you.
trespasses.
Yes, thank you very much.
Thank you.
Tort, unlike criminal law, okay, where you can easily take it for granted that we have general defenses and so on. You have to be careful when you are dealing with law of tort, because tort is like what you call like a forest, okay? Forest, when you're far away, it looks like one entity. But then as you get closer, you notice that each tree is standing on its own. So in the law of torts, that is how it is. It appears as one unified area of the law, but that is not true. If you are dealing with negligence, tort of negligence, we can talk of like defenses to tort of negligence. If you are dealing with like intentional tort, like the trespass to persons, depending upon the particular tort, you also have the defenses. You are dealing with defamation. Even within defamation too, we also have its own set of defenses. So we don't have like generalized defenses, because torts are of a different category. But for the major category, maybe you are talking about negligence. Yes, we have like a general defenses to negligence. You are talking about defamation. That way, you are talking about maybe trespass to persons, like maybe battery and assault, lawful arrest, false imprisonment, malicious prosecution. So that is how it is. Okay.
Thank you.
Okay, so let me quickly run you through something I wanted to do with you. Okay, so quickly we are going to quickly revise court structure. We'll be revising judicial precedent, and we'll look at the civil procedure, criminal procedure, ADL, and statutory interpretation. Yeah, so that we know we finish with the legal system. Okay, so at this stage, I am sure that you've all made effort to look at the court structure, because it's a favorite area. Almost every exams is an area that you feel confident that it is fair for every student who claims to have learned legal system to know. So it's an area examiners like, just like source of law that we've talked about already. So you know that our judiciary comprises two main categories of court: the superior courts on one hand, and then the lower courts, which used to be called the inferior courts. So the superior courts comprise the Supreme Court, the Court of Appeal, the High Court, and the regional tribunal. and then the lower court. So the High Court and the original tribunal, as you notice, are courts of coordinate jurisdiction, meaning that they are at the same level, none is superior to the other. Again, the lower court will have the circuit court, district court, the juvenile court, and then the judicial committees of the House of Chiefs, as the case may be. So it is important that you have a mental picture or a mental map of these courts all the time. So for the Supreme Court, we know the composition, and we have to know like the jurisdiction. So the composition, as you recall, the Supreme Court comprises the Chief Justice plus not less than 9 justices. So maybe the point I will flag for you is that as part of the ongoing debate, there has been a concern as to whether we should cap the Supreme Court. In other words, should there be like a fixed number? So maybe that is something that you may also want to think along. Be interested in that debate. Should the number of Supreme Court justices be fixed in the Constitution, or should it be left open? So currently, as we notice, we have almost about 19 or 20 Supreme Court justices, as the case may be. So be thinking along that line. So assuming you are invited to speak to an issue like that, as whether you make a case that the number of the Supreme Court justices should be capped or not capped, what will be your arguments? So if you look at the arguments going around and from vetting of various nominees of Supreme Court justices, the thinking is that to cap the Supreme Court number, then we must also make changes to the caseload. And then the caseload which goes to Supreme Court is also dependent upon the jurisdiction, the various or the various or multi-jurisdiction which the Constitution has actually conferred on the Supreme Court. And that end up letting the Supreme Court be saddled with heavy case load. And that is why the supposed expansion of the membership of the Supreme Court currently to even 20, some will argue is even reasonable. So if it is necessary to cap the number to fix it, then we need to also make changes to the jurisdiction conferred on the Supreme Court. So as we know, the Supreme Court has original jurisdiction, and then the Supreme Court has the final appellate jurisdiction. The Supreme Court has supervisory jurisdiction. It also has its own unique review jurisdiction. When it comes to special documents, the Supreme Court has jurisdiction. When it comes to presidential elections, Supreme Court has no jurisdiction. So, and if you look at it, in terms of even the appellate one, the Constitution will say that any case which started from the High Court, the appeal lies of right. So meaning that if you want to appeal from the High Court, the Court of Appeal is automatic. If you want to appeal from the Court of Appeal to the Supreme Court, it's automatic. So long as the case started from the High Court. The only occasion where it will not be automatic is if the case started in a court below the High Court, in which case you need a leave. Other than that, if the person wants to appeal, regardless of how frivolous the appeal may be, it lies as of right. So you end up having so many cases getting to the Supreme Court. So if we are debating capping the size, like having a fixed number, then we must at the same time have a consequential amendment or reform of the type of cases or the jurisdiction exercised by the Supreme Court, okay? So that was just by the way. And I'm sure at this stage you know that when the Supreme Court is exercising ordinary jurisdiction, the panel is 5, and then the most senior will preside. If the panel is 5 and then there has to be a review, then it's funded to 7, as it were. So in terms of the jurisdiction or the power of the Supreme Court, we're talking about it a lot, so we not belabor the point. And we, just a minute. Then let me, I think there's a problem with my word. I didn't know that. My computer screen is not stable. So what's the matter? I think there's a problem. Why is the screen shaking? Yeah. I'm not gonna. I hope it's to better now. Okay, so let's keep that in mind. You talk about the original jurisdiction when we're discussing constitutional law, so we know belabor the point. And we've also discussed the peculiar challenge which arise regarding the relation between the High Court and the Supreme Court as far as the original jurisdiction is concerned, particularly so in terms of Article 33 of the Constitution, which says that the High Court is the forum for enforcement of human rights, as we saw in the case of Ibel Leduse against Attorney General. And if the Supreme Court will have a role as far as the human rights are concerned, then it has to relate to matters of interpretation and then non-personal enforcement, just like you saw in the case like the Anna Ampofo AJ type of case, the pit latrine case. And also the same thing with respect to Mensima against Attorney General. And then the Abu Ramadan case, they all reinforce the point that where a matter relates to enforcement of the human rights, then you have to go to the High Court. However, where it involves human rights, but then there's an interpretive issue, okay? In that case, just like a jump of case against the National House of Chiefs. If you look at the Chieftaincy Act, for example, there used to be like a provision that if a chief summons you and then you don't go, like you committed an offense. And he also viewed that that is violative of the human rights to freedom of movement. So when he took the matter up, on the face of it, you would say that if it's freedom of movement, then it's got something to do with the fundamental human rights. So why not go to the High Court? But here, he was seeking the enforcement not for his personal benefit. And that was why the Supreme Court also saw it as an interpretive issue and decided to be seized of the matter rather than letting it go back to the High Court as it were, as happened in the case of Ibele Dusay against the Attorney General. Another point which we have noted is also that where there's a matter before any court, and an interpretation point arise, the proceedings in that court will have to be stayed, and a reference is made to the Supreme Court and Article 130 clause 2 for that. So if you look at the new prohibited through the third against Attorney General, it's a good illustration also of how that was actually done. Now, in terms of the Court of Appeal, maybe before I leave the Court of Appeal, I leave Supreme Court, in view of the recent issues about the Chief Justice, I don't expect that your examiner will be interested in asking you a question around that. But since we don't have benefit of what question is going to come, it's prudent to be interested in any area relevant to what we are learning. So I think that there's been a case regarding an Article 146, that is the removal process or the removal framework for removing a justice or the Superior Court, and for that matter, the Chief Justice, especially from office, as to whether that provision, for example, should be amended or it should be retained as it is. So it is something that, as I said, we don't expect anything like that, but as they say that never say never, isn't it? So once it is a current issue and it's relevant, it's worth also thinking about it. So Article 146, for example, procedure for removal of the Chief Justice, procedure for removal of Superior Court justices, and other analogous appointees. Is it fit for purpose in terms of guaranteeing independence of the judiciary, in terms of independence of whatever independent bodies who are also supposed to be amenable to similar framework as under Article 146. So those are the kind of things that we may also want to think about. So if you are thinking about independence of the judiciary, you must also think about the appointment procedure of Chief Justice, appointment procedure of justices, appointment and the removal procedure as well. So you have to think about those matters as well. Okay, good. I'm not going to give you any specifics, but I've just flagged that because of the current issues, it will not be out of place if you think about it. Then with respect to the Court of Appeal, we know that the Court of Appeal is comprised of the Chief Justice and not less than 12 justices. And the qualification, a lawyer of not less than 12 years standing, of good conduct, proving moral conduct, integrity, and so on. So that is it. In terms of its sitting to do its work, we know it's always made up of 3 justices, not like Supreme Court is 5. In terms of jurisdiction, the Court of Appeal has only one jurisdiction, appellate jurisdiction, so that it cannot deal with any case for the first time. Any case it is dealing with must have been considered in another forum before coming to it. So that is one thing we have to keep in mind. And Supreme Court decisions are binding upon it, just like any other court within the legal system. And decisions of the Court of Appeal is binding on the Court of Appeal. And then it's also bind lower courts. So if you look at the Supreme Court, as you notice, in terms of Article 1, 2, 6. No, sorry, 1292. That the Supreme Court shall not be bound to follow the decisions of any other court. And then 3, the Supreme Court may, while treating its own previous decision as normally binding, depart from the previous decision when it appears to its right to do so, and no other court shall be bound to follow the decision of the Supreme Court on the questions of law. So the Supreme Court is, as a general rule, not bound by its own decision. However, before it will decide not to follow its own previous decision, it must give a reason why it is making such a departure. But in the case of the Court of Appeal, it is bound by its own previous decision, except where it can use the mechanism of distinguishing and so on, which we'll be talking about in the judicial precedent very soon, in order not to follow it. Otherwise, it is bound by its own decision. And the decision is also binding on all other courts below it. But where you have two conflicting or more conflicting Court of Appeal decisions, then the court may choose between them which one it wants to follow and which one it does not want to follow. So if you look at our jurisprudence, you look at the Young against the Bristol aeroplane, for example, we seem to follow the position that the decision of the Court of Appeal is binding, and for that matter, where we have like a conflicting decisions, the court is at liberty to choose any of them, and it will not be wrong. Because unlike the Supreme Court, where it can make a departure and give a reason position. So High Court and the original tribunal, as we have indicated, they are court of coordinate jurisdiction, but you shouldn't confuse them. Despite the fact that they're on the same pedestal or they are of the same status, they have unique jurisdiction from each other. So the High Court, as we know, its jurisdiction is in all matters. So it has broad original jurisdiction, civil and criminal, meaning that all manner of cases, be it civil or criminal, can be taken to the High Court. The only exception be that when it comes to interpretation and enforcement of the Constitution, save fundamental human rights under Article 33, in which case the Supreme Court has a jurisdiction, the High Court has jurisdiction in all matters, as it were. So whatever case that you can take to district court, to the circuit court, and so on, the High Court can deal with that case. And apart from the original jurisdiction in civil and criminal case, it also has the supervisory jurisdiction over lower or inferior courts below it and other quasi-judicial bodies. So you look at cases like the Ex parte Electoral Commission, Ex parte Kokoroko, and so on. The High Court will use the prerogative of prerogative rights, certiorari, prohibition, mandamus, quo warranto, habeas corpus, and so on, to ensure that lower courts or quasi-judicial bodies stay within the limit defined by law, and then they also uphold certain sacred principles like natural justice and so on in the discharge of their work. For regional tribunal, as we have noted, yes, it's of the same status as the High Court, but its jurisdiction is quite unique. So under the law, it deals with only criminal offenses. That is offenses against the state and in the public interest. Now, let me say a few things about the regional tribunal, which is a matter of interest for your examination. In view of the vetting of the Attorney General, okay, and also the stated policy position of the current government, it will not be out of place if you are invited to also wade into the debate as whether the regional tribunal should be reactivated. Should be, in terms, it will be wrong to say it should be reintroduced because the regional tribunal is already part of the constitution, and as far as the constitution is concerned, it exists. But except that for quite some time, it has not been reactivated. In other words, it's not been functioning, but it doesn't mean that it does not exist. So the argument is it a good idea to revive or to reactivate the regional tribunal? Well, arguments could be made that insofar as they find it necessary to set up maybe like special courts or like the financial and other economic crimes division of the High Court. Now, what it means is that there's a need for the regional tribunal to be doing what the framers of the Constitution envisaged it to do, to be dealing with those type of special offenses, including corruption, piracy, and so on. Then there's a case for it to be revived. So just think along line those issues, assuming you're invited to express some views. But in the case of Yebi and Avalifo, Republic versus Yebi and Avalifo, the Supreme Court rejected the idea that the original tribunal shared the High Court's full original criminal jurisdiction. The High Court has no limit as far as its jurisdiction is concerned when it comes to, let's say, criminal cases or in civil cases, apart from the interpretation remit of the Supreme Court. But the regional tribunal, if you look at the thinking of the framers of the Constitution, why the regional tribunal was set up, you notice, and as Yebi and Avalifo actually also pointed out, that the regional tribunal does not really share the High Court's full original criminal jurisdiction, and its jurisdiction is limited as actually conferred by the Constitution. Of course, the lower courts, or what you used to call the inferior courts. So we have the district courts. We are not going to belabor that, but in terms of like the jurisdiction, that is what is really important to me. So if you take like the district court, for example, you have to note that when it comes to criminal offenses, it has a very limited jurisdiction. For example, it cannot deal with the offenses which can impose a custodial sentence of more than 5 years, or let's say 500 penalty units. So let's keep that in mind. And for that matter, if there's an offense which is more than the statutory minimum, which has punishment of statutory minimum more than the cap, that is 2 years or 500 penalty units, then it cannot be done at the district court. And if it was done there, that will be a nullity as it were. And for district court, one basic thing we should notice is that it is limited to particular territory, to particular district. So the district court of Amasaman cannot deal with cases from the district court of Hohoi or the district court of Nsawam, as it were. So let's keep that in mind. Now, if you read my book, these are just summaries of the lengthy discussion in those books, so you can just relay the details from them. Now, let's say a few words about precedent. Judicial precedent, very important. We have to know what binds, how to extract, and how to avoid. So the doctrine of judicial precedent, as we recall, the basic idea that past or previous decisions of a court of competent jurisdiction should be applied to similar cases which reoccur. So if a matter has been decided before, and we have a new case whose facts are materially the same as the one which was previously decided, then you don't have to reinvent the wheel. Well, if you go to the Ghana Law TV, all these things we are doing, we've done a full lecture discussion on them. So what we are doing here is not a lecture. We are just having like a tutorial, just a revision tutorial. So if you need a full discussion, go and play some of those things and or read the relevant chapters in the books. So the idea about judicial precedent is something which is associated with the common law tradition, as you know, because the whole common law architecture is based upon judicial precedent or stare decisis. And that is why we say that we talk common law is a judge-made law, is a decisional law. And a decisional law, because you use previous decisions to decide similar cases which come up. So in that respect, decision of the Supreme Court, as we have seen, binds all courts. The Supreme Court itself even follows its own decision, except that it can depart from it where there is a manifest error or where there is a need to settle conflicting lines. And if you look at the recent case of Oje Edum Obranun Kwesiata, the 6 against Ghana Telecom and Lands Commission, it's made that point that the Supreme Court must actually hold itself in restraint and must not ignore its past decision at will. It must do so only where it identifies either particular error or that there's a problem or some injustices associated with that position, for which reason is making a departure, because its decision gives a direction to the entire legal system and no other courts follow that. Now, the Court of Appeal, as we have seen, is bound by the Supreme Court and also by itself, and then lower courts must also follow it. And we've seen the situation of where there are conflicting positions, so we will not belabor that. But when it comes to precedent for the High Court and the Original Tribunal, decision of a High Court is not binding on another High Court, but it is persuasive. So, and then decision of the Regional Tribunal is also not binding on the High Court because they are court of coordinate jurisdiction. But where a High Court has decided the matter and there is no Court of Appeal decision, there's no Supreme Court decision, then you cannot ignore what a High Court decided unless you have some other superior reasoning which you think should be stated. Otherwise, there's no point in you ignoring what one high court has already decided. Even just like the Supreme Court, if there's a matter before the Supreme Court and there's no Supreme Court decision, there's no Court of Appeal decision, and there's a high court decision, if it's a good decision, the Supreme Court can adopt it and approve it and follow it, as it were. So to have judicial precedent or stare decisis operating, as we've learned already, there's a need for law reporting. There's a need for decisions to be reported, to be recorded. Because decisions are not reported, how will you know that this matter before you, another court has dealt with it before? So when the decisions are reported in the law report, then it becomes very handy for people to know that these decisions are there. And that is why in Ghana, we have like the Council for Law Reporting, but these days with the internet, it's relatively easier for decided cases to be made available. Another important point to note when you are talking about judicial precedent or stare decisis is what we call the ratio decidendi, as opposed to obiter dictum or obiter dicta. So ratio decidendi is that aspect of the decision which serves as a precedent. So what is the ratio decidendi? Ratio decidendi, as you recall, is basically the legal rule necessary to decide the case on its material facts. So when there's a case and then the court has extracted the essential facts in the sense that all the other embellishments, all the other unnecessary preambles and surrounding diseases are ignored. And then we come to like the rare heart of the story, the rare heart of the matter. That is the material facts. Now, the principle which the court is going to use to reach a decision on the material facts is what we call the ratio decidendi. So if you look at my book, I've discussed it extensively, a very lengthy discussion there. So what I have is just a summary from there for purposes of just doing this discussion with you. And if you look at the Halawi against Idra funds, for example, we will be reminded that it is the principle underpinning the decision which binds. In other words, if you take the case in terms of the case serving as a precedent for future cases, you need to know what was like the rare scenario, the material facts, okay? What was it? And what principle did the court use to decide it? So that will give you like the ratio decidendi. For example, as you remember in, let's say, the case of Donoghue and Stevenson in tort, for example, and I'm sure you all remember Donoghue and Stevenson and subsequent like Caparo and Dickman and so on. If you take Donoghue and Stevenson, for example, the material facts will be where a manufacturer has manufactured something which is supposed to be consumed, and then is presented in a way which the consumer cannot have the benefit of actually ascertaining the full content in terms of its wholesomeness, okay? Then something goes wrong after consuming it. Should the manufacturer be held liable or should not be held liable? And that is where the court will come and say that in a situation like that, then there's a duty of care. There's a duty of care in the sense that there was what we call a certain proximate relationship. Proximate relationship means that the manufacturer, in the circumstances that I have narrated, ought to have known that if he did not exercise reasonable care, requisite care in carrying out the manufacturing, in packaging it, so that if the final consumer gets it and consume it, nothing untoward will happen. Then he will have been in breach of obligation or a duty imposed upon him by law to ensure that nothing untoward is done regarding the manufacturing. So that is how the ratio descender is taken. So therefore, in future cases, if you have like a story or a scenario where somebody, for example, has done something and it's meant to be used by others, and then it's packaged and then it's presented in such a way that the user does not have the means or the ability to actually uncover any defect in it, and he or she is supposed to use it, then you say that on basis of the decision in Dodogo and Service, the court will recognize existence of duty of care because there's that proximate relationship. And that is why Lord Atkin will cite cases like Heaven and Penda and so on, and will even try and adapt the Good Samaritan principle that if you are located, not geographically necessarily, but if how you are related to people is such that if you don't have them in mind when you are acting, as whether your action or your mission will cause an injury to them, and you just act in this disregard of them, then if an injury occurred to them, the law will fix you with what? With a duty that based upon the closeness, the proximity of the relationship between you and your neighbor, there was a duty on your part to exercise requisite care and avoid causing an injury. So that is how the ratio decidendi is actually extracted. If you have a case and then the ratio decidendi, for example, cannot be extracted, then it becomes problematic, meaning that in terms of precedent, it cannot be used. Now, the obiter dicta is the aspect of the case which did not actually decide the material facts. Nevertheless, it was an important statement of maybe the law or how the law should be or what the law will be. So, obiter dicta is not binding, it's only persuasive. And oftentimes, how cases are cited by lawyers, and most of the time you look at them, they're actually not referring to the ratio decidendi. They are using an obiter from that case to try and persuade the court. Because if you have the ratio decidendi properly extracted, and if you can demonstrate that the material facts of the case on hand are the same as the material facts of the particular precedent in which you have the ratio extracted, then that is binding. But as I indicated, the obiter dicta is just, by the way of side comments, which may be an important solution to future problem, but it's not relevant to the current problem in the case. And that's why I say that it's only persuasive, as it were. So if you look at the high trees case, which all of you know, promissory estoppel. Promissory estoppel, the high trees case, as you notice, there are two sets of factual scenarios. The first one relate to the immediate and the most important problem. after the Second World War, the tenants or they had been in default. Okay, they had been in default of arrears for some months after the end of the Second World War. So that's the one aspect. And then the other aspect is that during the Second World War, when the property owners themselves told the tenants not to pay the full rent. Now, they wanted to find out what the court think. So the court went to pronounce on that portion. But that portion, as a matter of fact, was not an issue. It was not a matter in controversy. What was in controversy was the other arrears, which had actually accrued following the end of the Second World War. That notwithstanding, you see how the beautiful statement by Denning J, as it then was, will now become an important reference point in future cases in trying to refine what we call the doctrine of promissory estoppel. So to know the ratio dissidenda, you get the material facts, and then we state the applied legal principle in that case. So the applied legal principle plus the material facts will give you the ratio dissidenda. But there are instances in which the ratio dissidenda or the precedent, let me put that, in which the precedent may not actually be followed. In other words, under what circumstance will a binding precedent not bind or will not be applicable? One, where the precedent was per incuriam in the sense that the decision was made wrongly as it ignored a binding statute or authority. So if a decision was made by a court whose decision is ordinarily binding on other courts, but then can be demonstrated that when that court made that decision, there was a particular legislation which was relevant to the matter, which the court did not cite, and for that matter, could be said to have ignored any decision, and that makes the decision wrong. So let's keep that in mind. Or it may well be that there was a certain precedent which should have also been taken into account, but that one was not taken into account, and it will make the decision wrong. So the decision is per incuriam. So if a particular decision is cited before you as a court, or somebody is citing it, another party can demonstrate that, yeah, despite the fact that that decision ordinarily will be binding, it was given per incuriam in the sense that it ignored a certain applicable legislation or authority, then that will be it. Then it's no longer binding. So, so if you look at the Loga and the Davosi, I've cited and provided the details in my book. You will notice how the court actually said that you don't need to follow. Yes, I'm teaching online. Yes, I'll call you later. It's okay. How the court actually explained that if the decision which ought to have been followed as a binding precedent was, for example, given an error, like us ignoring a binding statute authority, then need not be followed, and that is it. Another instance in which a binding precedent may not be applicable is through distinguishing. Distinguishing simply means that there's a precedent which ordinarily should have been followed, but then you're able to demonstrate that if we look closely and critically at the facts in the instant case, there are some important dimensions in the instant case, which were not present in the facts of the precedent, which on the face of it look applicable. So because you're able to point out an important distinction in terms of the factual, configuration or the factual aspects of the present problem from the precedent, then you don't have to follow it, because the basis for precedent is that you are applying like decision to like cases. So if the cases are not alike in the sense of the material facts over there differ somewhat from the material facts in the present case, then the foundation is not laid for that precedent to be followed, and then you don't have to follow it. So, and this is a very important skill which you need to develop, ability to distinguish, and that will enable you to get away with an otherwise binding decision. Another way in which precedent may not be binding is where you have like the change circumstance, like change circumstance in the sense that, or there has even been like overruling. Maybe you have like there's a decision which has been overruled. If it has been overruled, or maybe like in the Supreme Court has made a departure from an otherwise binding Supreme Court decision, then so be it. Another important point is that we need to appreciate what we call the res judicata. So if you look at my book, I think the volume 1 or so, these have been discussed like extensively, and res judicata is different from judicial precedent. So, okay, they are not the same. Res judicata prevents or bars real litigation between the same parties after a final judgment, even if legally wrong. So there's a particular case in which I've actually reproduced the decision of the court, trying to draw the distinction between that, and then stare decisis. So, res judicata, the idea that litigation must come to an end, and if the same parties of their descendants in title, as it were, have actually litigated a matter before, and a decision has been given on that matter, then that is it. It cannot be litigated again, even if the decision is wrong. So if you look at the judicial precedent, we are told that where the decision is wrong, it's not binding. When it comes to res judicata, it's not like that. Res judicata, you cannot say that yes, we've litigated this matter before, and there has been a final judgment, but then I don't think that we should be prevented from re-litigating because the previous final judgment was wrong. No. Even if it is wrong, so long as we didn't appeal or didn't take any step, it is binding. Unlike judicial precedent, so don't let us confuse the two. The only exception would be where maybe the decision, the earlier judgment, which was final, was obtained fraudulently. Then the authorities are that fraud vitiate everything, and it will pave way for the matter to be, re-litigated because the earlier one was fraudulent, as it were. As I said, if you want to know details about this, go and read this. This is just a summary of the book. We will not belabor this one, but I also have like a topic on the legal profession in the book, which attempt to explain matters that you will know already. So I'll not waste time on it. So let's talk briefly about statutory interpretation. Statutory interpretation is also a topic in legal method. So if you look at the volume 2, I've also discussed that. Well, if you look at the questions which have come before, I have not seen any question on statutory interpretation before. I don't know if any of you have seen one before. Has there been a question on it before? Has there been a previous question on statutory interpretation ever since they started the law school entrance examination?
No.
My Lord, no, we've not seen anything like
I haven't
that.
seen anything. Okay, all right. But as I said, since we don't know what question is coming, it's better to briefly remind ourselves. Yeah, so when it comes to statutory, of course, the whole course we will do later on, but at the LLB level, when it's taught as part of Ghana legal system and legal method, we are reminded that where there's a need to interpret a provision in the law, where there's a need for statutory interpretation, that is because there's ambiguity, because the provision is capable of bearing more meanings or rival meanings, then we need to be guided by certain rules. What do you call the literal rule? The literal rule, or what you used to call like the primary rule of interpretation. That approach looks for the plain or the ordinary meaning. It is a view that the legislation is written in English language. So in ordinary English language, what is the meaning of whatever is presented? So what is the ordinary meaning? What meaning will the user of the English language make of it? So as you know, in cases of a peerage, ex parte Daniel, and then ex parte Shraj, so many cases. So the court will just go after the plain meaning, ordinary meaning, even if it's inconvenient. In other words, even if it's not like the best of outcome, so long as that's ordinary meaning, that is what the court will go for. So if you remember the case of ex parte Shraj, and Anani, the interested party, the case in which Dr. Anani, who had been charged with the corruption and was being investigated by Shraj, and then the Shraj made adverse funding. The matter went before the High Court, and I think the High Court actually, and then eventually to the Supreme Court, made the point that if you look at the provision in the Constitution relating to Shraj, up to the functions of the Shraj, they are supposed to receive complaint, right? Complaint of corruption against the public office holder. And the complaint was interpreted to mean that there should be a complainant. So like just trying to use like the ordinary meaning that yes, a complaint means that there should be a complainant. So Shraj had actually looked at the newspapers to follow a story relating to the minister, and then has gone on to do investigation and made adverse findings against the minister. That was the Dr. Richard Anani, and then he challenged it later in court. And then the court sought to interpret whether Shraj had actually assumed jurisdiction, had actually exercised his powers. And then the court said that, well, the case is a supposed one of corruption. So who was the complainant? And Shraj did not have a complainant. So the court just tried to interpret the word complaint and said that the complaint here will mean that there should be a complainant. So that's like the ordinary meaning. Well, there are times that the literal meaning, which is like the starting point, may not yield the preferred outcome in terms of the justice of the situation. So where the literal meaning is absurdity or inconsistency, absurdity as in like the unreasonable outcome, an outcome which defies logic. Then, as the case where the Gray and Pearson, for example, will remind us that we need to depart from the literal meaning and rather go after a meaning which will avoid absurdity, or to avoid the repugnance or the unreasonableness. So that is like the golden rule. And we also have what we call the mischief rule. The mischief rule, and the mischief rule actually looks at, there's a case which we call it the Hayden's case, which all of you, I'm sure, you have read before. And in the Hayden's case, the courts propounded 4 questions which should actually guide the interpretation, among other things, to find out what was the previous position of the law, like the particular law you are trying to interpret. Before that law was made, what was the situation before? Then what was the problem? And then what solution was propounded to solve that problem? And why was that solution? So does it cure the mischief? So the mischief is like the problem. What was the problem? What was the mischief? And what solution did the lawmaker provide to cure the mischief? And why? So if you look at even the Article 106, okay, of Article 106, Clause 2A, the word mischief rule is not used. But what the framers of the Constitution have done is to try and provide the substance of the mischief rule as one of the guiding points for the lawmakers in trying to exercise the legislative power. And let me tell you how it is. So if you look at the 106 2A, it says that the bill shall be accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defects of the existing law, the remedies proposed to deal with those defects, and the necessity for its introduction. So this is another, if you like, rendition of the 4 questions in the Hayden's case, what like the mischief rule is about, what the position of the law was, the mischief, the problem, identify the remedy fashion, and then the reason for that remedy. So if you look at the case like the Asari against the Attorney General, J. Chum against Attorney General and Akwete, again, next party Shraj, these are all discussed. And I've copiously discussed them in my book. Then the purposive rule, which has given rise to what we call the MOPA, which law students in the law school know so well, the modern objective purposive word approach. So just those of you who have done international law, when you're doing the Vienna Convention on the Law of Treaties, you come across the teleological approach. So the teleological approach is the same thing as we call the purposive approach here. So here, the court seek the status purpose. Like, what is the purpose of the statute? So what purpose is the lawmaker trying to achieve by making this provision? So the court will try and provide interpretation which tries to advance the purpose which the lawmaker is trying to achieve rather than to undermine it. But the purposive approach, is a bit like a slippery slope. If you are not careful, you end up turning yourself into making a law. And that is why it is used with the restraint as it were. So if you look at the case of Pepper and Hart, for example, it was that case, of course, predated our Interpretation Act of 2009, which says that in order to understand the purpose for which the legislation was made, it will be useful for, if necessary, for the court to go and look at the legislative history of that particular legislation. So if there was any reports and other travaux perpetual, they can all be looked at to help the court to understand what the lawmaker was trying to achieve. Then we also have the internal aids and of interpretation and also presumption. These have also been discussed extensively, but because we are not sure whether these will come in exams or not, we'll not waste time on them, except that if you are talking about the internal is that if you look at the legislation, it has its own parts. The titles, the heading, the marginal note, the schedules, and definitions. They help in trying to resolve the ambiguity. Not too long ago, I think one of you referred us to the interpretation session of the Rent Act at 220, because it's supposed to provide an assistance in trying to understand or interpret the provisions of that particular legislation. So, but as I said, we'll not belabor the point, but they will discuss extensively. If you're interested, you can go and read more about them in the textbook. Then we also have presumptions. Presumptions, in other words, certain general conclusion, which we assume when we are interpreting the statute. For example, presumption against retrospectivity. When you're interpreting a statute, you interpret it with the view that the lawmaker never intended to make a law which will apply to matters which have happened before the law was made. That is retrospectivity. And then when it comes to serious crime, when you're interpreting, you have to interpret with the understanding that it requires a serious, it requires a menstrual for serious crime. That when the crime is very serious, then the requisite mental or guilty mindset should be very high. Then there should also presumption against the ouster of courts. You remember the case of Scott and Avery, and then Eslifi and Tete, as to whether you can enter into agreement or arrangement who try to say that a matter cannot be taken to court. Can you make any arrangement to deny the court jurisdiction? So there's a presumption that the lawmaker does not intend to deny jurisdiction to the court. And in fact, if you look at 125 of the Constitution, final judicial power is vested in the judiciary. So any law which says to say that the court does not have any jurisdiction whatsoever, it is problematic. And that is why we have the presumption against ouster of courts. And also presumption of coherence with the Constitution. The court will have to also interpret the law with the presumption that it's supposed to be in harmony with the letter and spirit of the Constitution, as you know. Yeah, so these are some of the few things we need to brush up our mind. Well, I have some few questions here, and these questions are questions which are already in my book. So I'll just pick them up for you. Yeah, these are all in the book. So I want to jump to criminal procedure and then the civil procedure briefly. So the other three topics we are supposed to know: overview of a criminal procedure, overview of a civil procedure, and also alternative dispute resolution, They're all part of the Ghana legal system and legal method. And again, these have also been discussed extensively. So for criminal procedure, you have to remember that ours is like the adversarial mode, and that is why you have a presumption of what? Innocence. That the accused person is presumed to be innocent. And let me say that I think last year or last 2 years, there was a question which requires students to just basically tell us the things in Article 19. And I'm told a lot of students still were not getting it. I think that's the rules on the fair trial. I think there was a question like that. Do you remember? Who remembers that question? I don't think last year or last 2 years. There was a question which requires students to just, and the substance of the question was actually you telling us about the rules of fair trial and Article 19. Very straightforward. So please, if you haven't looked at Article 19, look at Article 19, please. Look at Article 19 and know the rules of fair trial. Yeah, I don't have the question, but I remember something like that. Has been a question like that before, if I'm not mistaken. So the presumption of innocence, and also the principle of legality, the fact that offenses and penalty must be defined by written law, very important. Article 19, clause 11. So there's nothing like common law offenses. You cannot be charged an offense which is not defined in a written law, telling us exactly what the offense is, and then a punishment which is supposed to accompany it. So that is very important. Then we should also appreciate that when it comes to arrest, okay, like under the criminal, of course, the criminal procedure code, and also the NRC Decree 279, who can authorize an arrest with or without warrant. So if you are a state attorney, so long as you are above your state attorney or above the rank of state attorney, you have no powers of the police of arrest under Section 30. Under Section 10 of Act 30, the police can arrest you without warrant. Now, a private person can also arrest without warrant, except that you, as a private person, if something goes wrong, you find yourself facing liability for unlawful arrest, false imprisonment, and so on. So that is just like a risk which you run, because as you know, there are requirements. If you look at the Constitution, the right to personal liberty, a person to be arrested, and be told the reason for his arrest in the language that he understands, his right to a lawyer of his choice, and so on. So you, as a private citizen, if you decide to effect arrest, I mean, that is permissible, but it's a risk that you are running. So please look at Article 14 to know the rules on the lawful arrest as well. The same way, if you're arresting, the person must be told the reason. If you are going to conduct a search, the search is permitted on reasonable grounds. Items which are exhibits, of course, you cannot remove somebody's clothing. And you also know that when a person is arrested, in terms of you detaining him, you must bring him to court within 48 hours. And you know the Martin Pebu line of cases, which have actually made the point that The 48 hours even covers weekends and holidays as well. Previously, there was that uncertainty, so you get a situation where the police will arrest you on, let's say, Friday, and then hope to keep you in probably till Monday. But if you do the calculation, that will see the 48 hours, except that maybe they decide to arrest you late, as it will. Then bail. We have a police inquiry bail, which is arranged at the police. And let me say that a bail is not payment of money, okay? A bail is simply an agreement between the person arrested or the person arranging the bail and the state that somebody who has been arrested or detained, that person will reappear. And should he or she not reappear when so needed, then a certain amount of money will be forfeited to the state. And that is the sense of a bill. So it's not about payment of money. So let's keep that in mind. And that is what we have what they call the treatment of a bail bond. But later on, you will discuss more about that when you're doing criminal procedure as a course in the part 1. Again, we have to remember that the bail is discretionary. Discretionary in the sense that it's not automatic, particularly so where the period for not granting bail has not elapsed. But of course, all discretion must be exercised judiciously or judicially, and it should not be withheld as a means of what as punishment. Mind you, the person is still presumed to be innocent, and so long as you enjoy the presumption of innocence, you cannot use detention or you cannot use the denial of a bail as a punishment. So, what are some of the factors which may be considered in making a decision as to whether a bail should be granted or not? Has the person demonstrated is he a person in flight risks? Is he someone who will disappear, he will run away? Will he interfere with investigation, which is still ongoing? Or why on bail previously has he committed an offense, offending while on bail? So these are some of the, previously there used to be this requirement of severity of the offense. No. So the severity of the offense is not a ground for refusing bail. And then, like, as a person got the Facebook of, Facebook, the place of residence, employment, and those who are prepared to stand surety. So where, for example, a bail of 100,000 Ghana cedi has been put on a person, what it means is that should the person default in not appearing, that money will be taken from him or whoever signed or guaranteed the bill for him as a surety. And sometimes they'll say that maybe surety to justify. That is to say that if the bill is 100,000 and you are bringing somebody as your surety or guarantor, the person must be able to produce evidence of property worth the value of the amount. That is what it means to say to justify. So as I have indicated, Martin Pebu, Government vs. Republic, and then Martin Pebu has actually strike down provisions of the Criminal Procedure Code Act 30, particularly Section 96 thereabout, which made the point that for certain type of offenses, a bail was not automatic, or they were non-bailable offense. Now, all offenses are bailable. And the court had regard to Article 14, clause 3 and 4, and also Article 19, clause 2 and 6. Now, where there has been delay, of course, there's been a delay in arraigning a person before court and so on, then it's tilt the constitutional balance of the grant of bail in favor of the accused person. Another point which you have to remember is what we call nolle prosequi. These days, nolle prosequi has also become part of the news, so at least it's part of the court, but it's also a current topic, so it's good we know it. So nolle prosequi, which is a special power or privilege of the state exercised through the Attorney General under Section 54 of the Criminal Procedure Act, Act 30, enables the Attorney General to discontinue criminal prosecution at any stage before verdict or judgment. So before judgment is given or before the jury has given like a verdict in a trial, the Attorney General may enter a process known as nolle prosequi, simply saying that it is discontinuing the prosecution, it's not continuing the prosecution. And the effect of it is to discharge the accused person. And mind you, it does not acquit the accused person. The accused person is only discharged. Acquittal means that the court has considered your case and the court has come to the view that you are innocent, then you are acquitted. But when nolle prosequi is entered, the court has not determined the merits of your case. It's just the prosecution which has stated that it is no longer interested in continuing the prosecution. So you will be set free, you'll be discharged, but you are not acquitted. And nolle prosequi does not also bar or prevent future proceedings with the same facts. You can be re-arrested later and charged on the same facts, which you were previously being charged and it was discontinued. We can look at that Gregory Afoko against the Attorney General. And of course, these days, there are a lot of nolle prosequi cases, and the Attorney General has been also explaining in a lot of press conferences and other releases. So I'm sure you're all familiar with the process now. As I said, the Attorney General is the ultimate authority, but he can authorize other public prosecutors under him to have cases discontinued, as it were. But so let's keep that in mind. Now let's see a few things about criminal procedure before we go to civil procedure. So when it comes to criminal trial, you have two types. You have the summary trial and you have the trial and indictment. Okay. So for trial, which is on indictment, it will have to go through a preliminary stage. So the preliminary stage is known as the committal stage. So there's a committal, which is done at the district court. Again, what I'm talking about is just a brief. I have the thorough discussion in my textbook, so you can go and read that. But there's a committal stage in which the person who is to be tried will actually be put before the district court, and then they'll go through the bail of indictment to try and find out whether the charges being preferred against him are in order, the summary of evidence, the various documents which are going to rely upon are everything in order. They will go through a measure, and at the committal stage in the district court, we are not finding out whether the accused person is guilty or not guilty. No, we are just trying to find out the requirements of the law in terms of the bill of indictment, the summary of evidence. Is everything there? So that is how it is. So minute. Yeah, so at the committal stage, it's just to find out whether all the requirements for the indictable offense are in order. And as I said, it's done at the district court, not at the circuit court or the high court, only at the district court. But the trial will take place in the high court. So we have like the jury trial where you have a 7-member jury under section 244, Vac 30. And when it comes to offenses which require like death penalty, for example, automatically it will try on indictment. And when it comes to, of course, apart from murder, there are other offenses to which the Attorney General can actually elect that it should be tried on indictment. So that one is there. So assuming all the preliminaries have been done, then it comes to the trial and indictment in the High Court. You have to get the jury selection, and the jury too. Let me say this: in recent times, there has been a concern as to whether we should reform the jury. Okay, I think I have one session on that, that whether the jury. So there's a debate regarding like the jury. Should we reform the jury as we have? And some schools of thought which says that the jury is not fit for purpose because of so many reasons. So let's even scrap the jury and only allow the judge to sit, just like all other type of cases. So let's look at it. So the jury, to let us know how the jury is actually built, how in the particular district, how we compile the register for jurors. And then during the trial, once the register is prepared, like the pool of jurors is prepared, how do we get the seven, how do we get the seven jurors to sit? The box is brought, and then the sheriff or the court clerk will put his sign in it and bring out 1, 2, 3, 4. So when it's brought, the law allows the person to be tried, the accused person, to object. The like the first 3, you can just object. I don't want this person to be a juror. I don't want that person to be a juror in my case. I don't want that person to be a juror in my case. And you don't have to give any reason. What we call the peremptory challenge, okay? Peremptory challenge. So you can do that. You don't have to give any reason. But after that, after doing that, let's say 3 times, you need to actually provide a reason why you do not want somebody to be made a member of the jury. So there's what we call the challenge for cause. Okay, so you have to know the preemptory challenge and then the challenge for cause when it comes to the trial and indictment. So maybe of course, we don't know, but you could be asked to, for example, explain the difference between a peremptory challenge and challenge for cause in criminal procedure or jury trial. Then you have to tell us as it were. So it's not anything difficult as you will notice, but it's a question of whether you know it or you don't know it, but it's not difficult. Then, after the jury has been built, we will go through the plea, the taking of the plea, okay, of the accused person. And then the plea, about 4 pleas are available. For example, the making not guilty plea, of course, meaning that you're denying the offense and you put yourself on the republic to prove your guilt. For capital offenses, whether you plead guilty or not guilty, the court will always enter not guilty so that you go through the full trial. Then we also have guilty. Guilty is judicial confession, but as I said, where it is a capital offense, even if you plead guilty, it will not be taken. It will be treated as not guilty. Then we have what they call the autrefois acquit and the autrefois convey. So what they call the plea in bar. You plea and say that I cannot be charged, I cannot be tried for this offense because I've previously been tried, right? I've previously been tried in respect of this offense. And if I'm to be tried again, I will be subjected to double jeopardy. So I was tried and I was acquitted. So therefore acquit, I was tried and I was convicted. Therefore convict. So there's the rule against double jeopardy under the Article 19 that no person shall be punished twice for the same offense. So if you have been previously be tried and you have been convicted or you've been acquitted and you are being tried in respect of the same transaction, the same set of facts, then when you are called upon to enter a plea, you can make a plea that you cannot plead guilty or not guilty because you've already been tried and previously convicted. So you are playing autrefois convict. You were previously tried and convicted. Or you are playing autrefois acquit. You previously tried and then acquitted, and that will be it. Then the court will look into it. If it is true, then you will not be made to stand trial again. So after assuming you entered not guilty, so they've gone through the evidence. The prosecution will call their witnesses through examination in chief, and then they are cross-examined. The prosecution will do that for their witnesses. When they have finished all their witnesses, the defense, the accused person will be called upon to open his defense. And instead of opening his defense, he can make submission of no case, trying to suggest to the court that when the prosecution case is fully considered, he has not actually made a prima facie case to warrant the accused person to open the defense. If the court look at it and then the court agrees, then that will be it. So in statutory character against the public, for example, of course, in so many other cases, where submission of no case is made, the court may uphold it where the court is convinced that there's no evidence on an essential element of the case. or the evidence presented has been so discredited that no reasonable court can civilly convict someone on basis of it, or the evidence is so manifestly unreliable, or even it's even imbalanced, as it were. In any of those situations, the court could say that the submission of no case has been successful. For that matter, the accused person can be acquitted, as it were. So these are some of the things that we should remember. But just some new things which have come up, which I'm sure you're aware, what you call it, the plea bargaining. The plea bargaining is a new addition which have been made to the law, which enable a person who is being charged and going to be tried for criminal offense to make some concession with the prosecution so that it will not be necessary for the whole trial process to be gone into. So you can, for example, plead guilty in return for you being given a lenient sentence, or some reach an agreement. If it's maybe about something involving money, then you reach an agreement that you are going to pay, or some other means. But the point is, the plea bargaining allows the accused person and then the prosecution under the supervision of the court to actually come to some kind of negotiation, a negotiated outcome, so that you don't need to go through the entire process or spectrum of the criminal trial, as the case may be. Okay, so I think that's enough for criminal procedure. You can read more about this in my book. Now, let's say a few words about civil procedure before we go. Well, maybe civil procedure, what I would say you need to remember are just the processes, okay? So the process, how do we start a civil procedure at this stage? At this elementary stage, what you need is the processes, the rate of summons, statement of claim, entry of appearance, statement of defense, encounter claim, reply, application for directions, witness statements, case management, and then the trial. Those are the things that you need at this stage. And because it's done at very introductory level, I don't think that you will be taxed so much. But as I said, because we don't know which questions are coming, it's just wise to revise everything so that you have an appreciation of everything. So the rate of summons is the process which you use to commence a civil case, to invoke resolution of the court, and then is accompanied by the statement of claim. The statement of claim narrates the story. So we have two main parties, okay, to civil case: the plaintiff and then the defendant. The plaintiff is the one who is making complaint that someone has violated his right or interest, and the defendant is the one against whom a complaint is made. So the plaintiff will set out a story in the statement of claim to accompany the writ of summons. It is served on the defendant. When it is served on the defendant has 8 days within which to file a document called appearance, indicating that he is aware that he has been sued and is ready to answer, and then he indicates his address where he can be served with subsequent processes. So after entering the appearance for after 8 days of being served with the writ of summons statement of claim, the defendant will have 14 days from the day that he entered appearance to file his statement of defense and counterclaim. So statement of defense is the defendant's answer to the allegations which have been made by the plaintiff in the writ of summons. Now, if the defendant also thinks that he also has a case against the plaintiff, he doesn't have to start a new case. He can present his case within the defense, and we call that counterclaim. So he will add counterclaim to send to the defense, and that is served on the plaintiff. When it is served on the plaintiff has 8 days within which to also file any reply that he may have. And then they will come to court for what we call application for directions, and the court will ask them to file the witness statements which they're going to rely on in their trial and so on. So in a nutshell, that is what really happened in the civil case. As I said, because these have not been examined, we don't want to spend so much time. Now, the other thing we need to look at the ADL. ADL, especially, I would like you to look at the customary arbitration, and in addition to the statutory or the non-customary arbitration we have under the ADL Act. So mediation, conciliation, arbitration. You look at that as when these have also been discussed in the book. So we will pause here, and then I'll take a few questions before I sign off. I have to go and do some other things, unfortunately.
Yeah, Doc, good evening.
Yes, good evening.
Yeah, please, it's just pleading that I want to make. A link, we don't have it on all your platforms. So I have to be calling a friend to share it with me. So I'm pleading if you can share
Okay.
it on all your platforms so that we can also be joining it.
All right. Thank you.
Yeah, thank you.
Yes, so no question. Have a good night.